The story that's been dominating many of the newspapers over the last couple of days is that of the exchange of properties of Mike Tymvios, and the fact that the government has now approved it. But the Attorney General has played down the government's decision to rubber stamp the agreement for the exchange of property between Tymvios, who's a Greek Cypriot, and a Turkish Cypriot landowner. Well, Achilleas Demetriades is a lawyer who's been specialising in the property issue for many years. He's on the line, hopefully to bring some clarity to what is a little bit of a muddy situation if you read all the different messages coming from all the different political parties. Achilleas, good evening.
Good evening.
For those who aren't familiar with the case, can you sort of in a nutshell summarise for us what originally happened? Because this is really a case, as I understand it, of somebody who waited and waited and waited and then sort of felt they could wait no longer to at least get something for their property.
Yes, that's actually a pretty accurate description of what happened. Mr. Tymvios had a lot of land in outside Kyrenia, in what is now occupied areas, and he had brought an action in 1990 before the European Court of Human Rights, just after the Loizidou case started. And his argument was, along with Mrs. Loizidou, that he was the owner of this land, and he wanted to get compensation for the loss of use, a rent, essentially. So the case sort of dragged on for about 18, 19 years, and then finally a judgment came out saying that in fact he was the owner and that he was entitled to rent. And at the last stage, which was the stage that the court would have to determine the amount of compensation that would be awarded, he actually struck a deal with the Turkish government by applying to the Immoveable Property Commission that was set up in the occupied areas back in 2006, if I'm not mistaken. And that deal entailed the exchange of his land in Kyrenia with land belonging to Turkish Cypriots, which was in Larnaca. In fact, it was an area that some schools had been built on, and it was land belonging to what was called back in the 60s the Turkish Communal Chamber, so it was Turkish Cypriot land. Now, his problem was that even though he struck this deal and also got some money on the side, the Cyprus government had refused to give effect to this exchange of property. So you would have the Greek Cypriot saying, I want to exchange this property, with a Turkish Cypriot saying, yes, I agree with the exchange, and the guardian of Turkish Cypriot properties would say, no, we can't do this. So he brought an action in the district court of Larnaca, where the property is situated, asking for the court for an order to force the government to effect this exchange of property. In the end, the Attorney General intervened and settled the matter by giving effect to this transfer of land, and also by proceeding and buying off Mr. Tymvios the newly acquired land he had from the Turkish Cypriot. So there was a package deal where the exchange was given effect, and Mr. Tymvios sold this land to the Republic of Cyprus because the schools that were on it were deemed to be necessary for the public interest.
Do we have any knowledge as to whether or not the problem arose because there were schools built on it, and if they'd gone ahead and said, yes, okay, the land's yours, he could have, I presume, said, okay, let's knock down the schools, I'm going to develop this. Was that the problem, or was it the principle of the thing? You said something interesting there about the guardianship of Turkish Cypriot properties, saying, no, we won't do this. Now, legally, what power does that organisation have to go against something that the Turkish Cypriots say?
Well, it's stronger than that. Is what power does the guardian have to oppose a settlement that was reached before the European Court of Human Rights, and in fact was given the stamp of approval of the European Court? Because Tymvios' case in Strasbourg was settled, and therefore the court gave a rubber stamp to it, and the Cyprus government was consequently bound by that, and that's where the case had a stronger element as opposed to a normal case.
All right, but even in a normal case, Achilleas, if an agreement is reached, a guardian usually is somebody who takes decisions when nobody else is able to take a decision, I think. Well, if somebody has taken a decision, surely it's nothing to do with the guardian.
Well, that's the irony of the term. they call it the guardian of Turkish Cypriot property, who is supposed to administer the properties while the Turkish Cypriots are away. In fact, there's quite a lot of bad administration of these properties, because a lot of them have been given to refugees at very low prices, who are then subletting them at very high prices. And there are all kinds of stories, horror stories, if I may say so, about the guardian. Now, from a legal point of view, it's quite interesting what you say, that if you're supposed to guard the properties when people are no longer there, if the people come back and claim it, you should be giving it back. I mean, that's the whole argument about the guardian, and legally I think it stands on very thin ground, and perhaps that's one of the reasons the government decided to settle the case rather than have the legality of the guardian being tested in the Cyprus courts and ultimately before the European court, because the chances of it surviving are not very good, I must say.
And that would be particularly embarrassing, of course, when we're President of the European Council.
Well, exactly. One more embarrassment.
Oh dear. Now, let's move on to whether this sets any precedents. The Attorney General has insisted it doesn't. I see in the paper today that the head of the Immoveable Property Commission in the North has said that it's a landmark that would likely act as a precedent for other cases. What's your view?
Well, I think, as a matter of fact, it sets a precedent in that we now have the seal of approval of the Council of Ministers on a decision approved in Strasbourg, and the decision having been taken by the Immovable Property Commission. And I think the government will have a very hard time to justify not allowing similar exchanges, whether these have been rubber-stamped by the European Court of Human Rights, or if they have not. I mean,
yes, because
I don't see the difference.
If you got your swap okay, why can't I have mine?
Well, exactly. I mean, are you prettier than me, or what?
I don't think I am, actually.
That seems to be the problem, and that, I think, it's not a legally binding precedent in the sense that there was a judgment whereby a precedent was created that has binding effect. But as a matter of fact, I think the government cannot avoid the reality of this decision. And the reality of the decision is that the decision by the Immovable Property Commission was given effect. And I have a lot of difficulty to understand how the government will credibly be able to stand up and say that, I cannot exchange my property in Kyrenia with your property in Paphos, because I think that this is a precedent that has been established in a practical sense, and it will now create a trend. More importantly, the Immovable Property Commission has always allowed the exchange of property, but nobody would take that option because everybody knew that the guardian would oppose it. Now that we have this indication from the government that in this case, for whatever reason, there was no opposition, and in fact we accept it, and not only do we accept it, but we went off and bought it from you, I think that gives the green light to a lot of people to start thinking, what sort of properties, what sort of Turkish Cypriot properties can I exchange my land with?
All right, and does this have to happen between individual people who own particular properties? It seems not, because the Tymvios land, you said, was owned by a sort of group of Turkish Cypriots.
Well, it's under the Cyprus constitution in 1960, there was what was called the Turkish Communal Chamber and the Greek Communal Chamber. These from 1963 have not been operating because of the political situation on the ground, but as in law, this Turkish Communal Chamber and Greek Communal Chamber effectively owned the schools that Greek or Turkish was taught, respectively. So they have quite a bit of property that has been sort of left registered in their name, and it's that kind of property that Tymvios exchanged his land outside Kyrenia with. So it's quite an interesting legal point in that. But I think as a matter of principle, it shouldn't make any difference who the owner is. I mean, it could be FGAF, which is the Muslim religious foundation on the one hand, or it could be an individual, or it could be companies. I don't think the identity of the owner has so much importance. I think the important thing is that the Republic of Cyprus has not objected to this exchange, and they may have good or bad reasons about it, but that's the fact. And this fact, I think, will be the beginning of a number of similar actions being taken.
Do you know to any degree how far the Immoveable Property Commission in the North facilitates this sort of thing? Because previously they were dealing only with monetary compensation. There was no swap. So this is a whole new ball game in a sense, isn't it? And the amount of compensation that was offered tended to be rather lower than people expected, but they took it in the end because something was better than nothing, was my understanding. Does this mean that maybe people will be able to get a fairer, if you like, price for the property that they will lose?
Well, I think the notion of fair and the notion of price is rather subjective sometimes, but and that's why I think that individuals should be allowed to strike their own deal. I mean, if you believe that your land fetches so much and you decide to sell it or get rent or exchange it, that is your personal individual decision because it's your property and that is your right, and that's what human rights are all about. And if you want to exercise this right by selling the land, exchanging it, keeping it because you think you want to go back and you owe it to your parents to return to your property, that is your personal decision, which you are entitled to take any way you like it. And I can't see why the state should be intervening in these personal decisions that people make in relation to their individual properties.
So, from here, then, people are more likely, it seems, since the compensation takes a long time to pay as well, doesn't it?
Well, you've got to come up with the cash, whereas if it's exchange, it's already there.
That's exactly what I mean. This could be the quick and, in a sense, easy in terms of speed solution. Very difficult, of course, for people, probably both sides of the divide, who will be saying farewell to properties that have been in their families for years. But it does seem to be a solution that will bypass all the problems that were raised with the compensation.
Well, I mean, if people decide to exchange their properties, they automatically exchange their claim for loss of use. So, in effect, that claim is cancelled out. But there must be a word of caution here. You must make sure that the land that you're trying to exchange is, in fact, vacant. Because if you have somebody sitting in it and doesn't want to move out, that is a risk that you have to take into account. For example, the guardian of Turkish Cypriot properties may have given this Turkish Cypriot property to a Greek Cypriot refugee because he didn't have a house and, they built a house on it, or they're cultivating the land. I mean, these are practical issues that one has to look at, and these practical issues have to be resolved if the exchange can take place. So it really opens up a Pandora's box of issues that are coming up, but that should not change the fact that this is something that is not excluded because it has happened.
It has indeed, and I'm sure the ramifications are going to be felt far and wide, certainly in Cyprus. And what about in the legal profession? I mean, does this mean that people who have already applied, those people who followed Titina Loizides with her case, a lot of them got something, and the ones at the back of the queue, they don't anymore because they have to go to the IPC, don't they?
Well, there's about 30 cases, actually 31 if I'm not mistaken, of judgments from the European Court of Human Rights which have been finalized. For one, this is the Lourdes case, I think we spoke about it. Mm-hmm. There was an award for 22 million euro. That is pending for certain procedural reasons, but I think that should become final sometime in the fall. And there is, these 30 cases have about 50 million worth of judgments attached to them, and Turkey is so far refusing to pay. Now, other than that, other people have already applied to the Immoveable Property Commission, and they're waiting in the queue. And the question that one has to ask himself, and I am not giving the answer either way, is whether one has to pursue this matter and try and get vindication through the IPC, and if that is not satisfactory, then go all the way to Strasbourg again, or one decides to wait until the solution of the Cyprus problem comes, and then, takes whatever is given at that point. That's a difficult issue that people have to address their minds to, and that's, I think, one of the biggest problems that people have to face, because it's now a real dilemma. You can either do the one or the other. Before, you couldn't really do much, and so there was nothing to decide. But now you have to think about it, and there are risks both ways. And it's a very hard decision for people to make, but it's nevertheless something that people should consider.
Well, what are the risks both ways?
Well, I mean, if you go to the IPC, you can apply for loss of use. That's granted. So you can get your rent, your loss of use of the property.
And that will be backdated to 74, yes?
That's from 74 to date plus interest. So that's pretty simple. The next question, though, is that you have to choose one of three remedies. The first remedy, which of course most people choose, and what I advise people is to claim back your property. The second one is to apply for exchange, which is now on the table. And the third one is to agree to the expropriation of your property. Now, if your property, for example, is now a dual carriageway, I can tell you that as a matter of fact, no reasonable court in this world will allow you to break up the dual carriageway and build your house on it. I mean, that's out of the question. So as a matter of public interest, the land will be expropriated and you will be getting your compensation. But
usually the expropriation of land means a much lower price, doesn't it?
It does, and this happens on both sides of the green line, and I'm not discussing how good the price is, I'm sort of discussing the methodology. Okay. I mean, we'll come to the pricing, which is a whole different ballgame. But if we just do the three sort of possibilities, the first one is expropriation, the second one is exchange, and now it's now open, and the third one is return to your property. Now, of course, everybody wants to return to their property, but if it was a big plot and now 50 houses are built, there is an issue there as to what do you do with these houses that are built on your property illegally, and this issue has to be resolved one way or the other. And if the argument is before the IPC that the public interest of the people living in this property is bigger than your public interest for returning, then I'm afraid that you will not be able to go back and that compensation will have to be paid. And this brings us to the big question of what is compensation. And that is the biggest problem involved, because what the Turkish Cypriots consider to be a fair price is not what we consider to be a fair price, primarily because we consider that the occupied area has depressed prices because of the Turkish invasion. And for example, in Kyrenia, the price of a property now, let's say for argument's sake, is 100, whereas we say it should have been 300, because in Paphos, which is a similar area, it fetches 300. And so the Turkish Cypriot will tell you that this price is only 100 because that's the going rate. You will reply to him that, well, that's not fair because there was an invasion and you destroyed the market and now you pay the low rate. That's not very fair. And then he will say back, well, yes, of course, you are actually using the results of the invasion because that has pushed up prices in Paphos, and instead of doubling, it tripled. So there is an argument there, who is right, but there is an objective answer to this, because one is at the beginning and the other is at the end of the scale. But we have 30 judgments from the European Court of Human Rights which give you markers as to what the court considers to be a fair price. And I'm afraid on this planet, justice is awarded by courts, and these courts have come out with judgments, and this is what it's all about.
Well, it's got to be about compromise to some degree, I suppose, hasn't it? Because nobody's going to agree as such.
Well, I mean, the unfortunate thing is that, lawyers have taken over the madhouse now, and lawyers are dealing with this issue as though it's a case, which it shouldn't. But that's just the result of the inability of the system to bring about a political solution. And now people are thinking, what do I do? I mean, my parents gave me this land. I've got all these kids. I need money. What should I do? Should I wait for the solution? Should I take things in my own hands? Difficult things. And,
I was going to ask you, Achilleas, you've dealt with a lot of people. I mean, have you detected, if you like, a weariness now about this issue, simply because, for example, you mentioned people who've inherited from their parents. I know that in some cases there are problems finding the names on title deeds and so on, and with each generation that it should pass down to, with more children, if I understand the sort of inheritance laws here correctly, the matter is going to get so complicated that the sooner it is dealt with per family, probably the easier it will be for them.
Well, my approach to this thing is that people should have the land in the names of living people. I mean, there's no point saying that my grandfather had 100 donums in Famagusta, and the grandfather had 3 kids, and each kid had another 4 kids. So you have, 12 grandchildren and 3 children. There's 15 heirs to this property. And what do you do with 15 heirs in a property? They take 1/15 each. You break it up. How do you do it? So you really need to follow the inheritance laws and decide within the family whether you take a property in shares. Let's say there are 15 plots, and you take 1/15 in every one of the 15 properties, or you take one property each for each one. And that's a family decision to be made. But you really have to take this decision and take the land off the grandfather, who has unfortunately passed away, deal with it from an inheritance point of view, so that the land is now registered in the name of living people,
and
who can then take a decision. Oh yes, I mean I've seen cases where the great grandfather has the land because nobody bothered to transfer the property after 74, and then the grandfather died. And
yes, but then can it still be done legally?
Of course it can. I mean, we have been blessed in Cyprus to have the Ottoman Empire create a land registration system, which was then perfected by the English. So our system is extremely good, accurate, and generates title deeds in the names of people. So we have a system which is very good. But people, for various reasons, have left things as they were back in 74 in the hope that they would soon return and deal with this matter. I mean, now 38 years down the road, this hasn't happened, and so people have to deal with it. And, the grandparents are dead, some of the parents are departing, and now the children have to deal with this. And the more you sort of pass it on to the next generation, the more complicated it becomes, and the more of a problem it is.
And that's what I asked you. Do you find that the people who are in this situation that you deal with are beginning to get very tired of it and just thinking, let's just do anything?
Oh, yes. I mean, especially people who are abroad and whose parents moved, let's say, in the States. They were born there. They never saw the area in the occupied, the place their parents were brought up in the occupied areas. They say, oh, I've got this land. How much is it worth? I want to sell it, and finish with it because, they have no connection to this, and that's perfectly okay. Others will say, I don't care. My grandparents grew up there. My parents lived there. I want to go back to my land. That's also okay. But these issues have to be decided, and the more generations are created, the less you are dependent on the land, and the less the emotional attachment to the land, and the more a chance for a monetary award to settle the matter is generated. So,
and of course, with this new ruling on the Tymvios case, as you said, now there is another option. It'll be very interesting to see where things go from here, won't it?
It'd be very interesting to see, because everybody will be in a mad rush to find the best properties to exchange theirs with. So I'll tell you, it's interesting.
It's always a pleasure talking to you, Achilleas. You make things so much clearer than the muddied waters that we tend to try and put together ourselves, piece together from what's written in the press.
Are they not simple?
Well, you would think so, but this does seem to have been going on for so long, and every time you think it's a simple answer, something comes up to sort of complicate things. So this time, possibly, although you say there are more options and it may be slightly more complicated, I think in a sense it might actually be simpler. But it's a pleasure talking to you as always. Many thanks for joining us.